I am Liz Stokes. I'm a partner at Hempsons, and I'm joined this morning by Rosie Harding and Emily, who are also at Hempsons, and we are all members of the Health and Social Care Advisory team at Hempsons, and we work for ICBs, NHS organisations, social care providers across the country, and are we provide advice and representation in all matters health care and social care. Today's session is around court of protection, and we do a lot of work both with acute trusts and with ICBs and in the community as well. As Heather says, we've got an awful lot to get through today. We are aware that the ICBs are currently in a situation of having to undertake a lot of COPDOL applications for community patients. We're aware that you have different systems for doing this, whether they're done all by one person or whether you have teams of people doing it, but there are variation across the country. But what we're intending to do today is to provide a practical run through of the application itself and certain the key issues. I'm shortly going to hand over to Rosie, and we're going to look at exactly when an application to the Court of Protection is required, but very briefly. And she's going to look at the acid test again briefly, and when the COPDOL 11 streamlined application process is going to be used. That is the focus of this session. So it may be that you have less or more experience of having made those applications. If you have done a lot of them, a lot of this information will be revision to you. If you have never done one before, we're hoping this will be a sort of a good start as to where and how to do it. There is a lot of information on the slides. We're not intending to cover it word for word, but the point is to have those slides so that you can come back to them and refer to them. The other thing that it may be useful to have in front of you when we're going through this is a copy of the COPDOL 11 form itself. I think we're going to put a link to that in the chat. So if you can, it may assist you to have that in front of you as an aside on the second screen or whatever, so you can have a look at that as we go through it. We haven't got it on the screen for you, so it may be helpful to have that next to you. We're not going to be able to address individual questions about individual applications. We know that each application is very particular to the circumstances of that patient, as it should be, and as is the point of the application in the first place. But we are, if there are questions at the end, and as Heather mentioned, able to hopefully have time to take some questions in regards to the process and application itself. So we're going to look at what happens once the application has been submitted as well at the end, and talk about some top tips. As I say, hopefully we'll have some time for questions and discussion at the end. So I'm going to hand over now to Rosie, who's going to take you through some of the background and the first steps in completing the COPDOL applications.
Thanks, Liz, and good morning, everyone. So first, we're going to have a look into when an application to the Court of Protection for authorisation of a deprivation of liberty is appropriate and required. I'm going to keep this very brief because I am sure that you're all very familiar with this, but it does set the context for the remainder of today's webinar. So when we're looking to identify situations where people are deprived of their liberty, and I'll refer to the individual as P in line with the MCA as we move through these slides, we're looking at two questions which together make up the acid test set out in the Supreme Court decision in Cheshire West back in 2014. So the first question is P subject to continuous supervision and control? Here we want to be thinking about factors such as the level of monitoring, what might happen if P wanted to be left alone, and whether P's movements are ultimately controlled by staff. The second question is whether P is free to leave. So here we're thinking about whether P can only go out if accompanied by carers, what steps might be taken to return P if they left the property, and is P on a sort of broader level able to choose where they want to live. So if we look at these two questions, and as a result, we have a person who is subject to continuous supervision and control and is not free to leave as a result of the care package we're commissioning, then we have a person who's deprived of their liberty, and we as an ICB need to ensure that that's properly authorised. In terms of when a court application for authorisation of the deprivation of liberty is required, there are 3 points here. P's care package has to meet the acid test, where the ICB is responsible for commissioning the care package, and primarily for COPDOL 11 applications, the care package is not being delivered in a care home or a hospital, because obviously then we'd be using the DOLS process and Schedule A1. briefly, we'll have a look at when the COPDA 11 streamlined process can be used. I say streamlined in inverted commas there because I think anyone who has experience of putting together these applications and the supporting documents might beg to differ. But they certainly do streamline the court process once issued if they're done well. So use of this process might be appropriate, and I say might because, as we've discussed, they are all case specific, but might be appropriate where there's no dispute that P lacks capacity to make decisions as to residence and care, and where all those with an interest in P's welfare, including the ICB and care provider, agree that delivery of the care package is in P's best interests and that the package is the least restrictive option for providing care and accommodation. And briefly, conversely, if we look at where the streamlined route might not be appropriate, where P is between 16 and 17, it will depend on the specific circumstances of the case as to whether you would apply via COPDA 11 or via COP 1. But do be aware that the court will list a court hearing where an application is made in relation to a person aged 16 or 17. Where there's disagreement as to P's capacity or best interests, the gateway to the COPDA 11 route is complete agreement, and where a dispute needs to be resolved through the court process, the COPDA 11 route is unlikely to be appropriate. Similarly, if implementation of the care plan conflicts with an advance decision or a decision made by an LPA or a deputy, then it's unlikely that the COPDA 11 route will be appropriate. And finally, if for some reason anyone, including the judge when you make the application, considers that an oral hearing is required, this can happen, for example, in cases where the level of restriction is particularly high or where there are concerns as to the implementation of the care package raised by the Rule 1.2 representative or someone else. There is guidance at the end of page 31 of the form, which you can use as a checklist to determine whether this application route is the right one. If you're unsure, then always seek legal advice. And finally, in this sort of whistle-stop tour of when you'd make this type of application, we're looking at what happens if the ICB doesn't make the application. So very, very briefly, if the ICB doesn't make an application where one is required, they may face a claim for unauthorised or unlawful deprivation of liberty, which can come with financial or reputational risks. And with that, I'll hand you over to Emily, who's going to give you an overview of the COPDA 11 and take you through the covering form.
Thank you, Rosie. So the COPDA 11 is split into several parts, and as Liz said earlier, you might find it useful to have this with you while we speak about it. The first section is the COPDA 11 itself, which explains the order that you're asking the court to make. Annex A is about the support and evidence, and Rosie will take us through this. And Annexes B and C are consultations, and we'll come back to this later. The first section asks if the application is urgent, and authorising a transition where care and support and residence and transition arrangements are agreed to be in P's best interests would make the application urgent. This type of application should be made as soon as possible in the process. Even if you think that the application is not urgent, it would be sensible to put in this box that the applicant relies upon section 4B of the MCA. This means that the deprivation of liberty is required for the purpose of doing a vital act through the provision of care, which is reasonably believed to be necessary to prevent a serious deterioration in P's condition. You should also include any factors that require particular scrutiny, including any arrangements that may not be in P's best interest. The order sought is usually split into 3 sections. Firstly, we'd include any declarations that P lacks capacity to conduct litigation, make decisions about their residence and care. If you need authority to enter into a tenancy agreement, it should also be included in this section. Secondly, there should be a declaration that it's in P's best interest to transition to or to continue to reside at their placement and to there receive a package of care in accordance with their assessed needs. Thirdly, it should be noted that to the extent to which the restrictions in place as a result of the package of care amount to a deprivation of liberty, and such deprivation is lawful and authorised by the court, we would then refer the court to the draft order. The duration of The order would usually be a maximum of 12 months, but you may consider a shorter review period if you know that there will be a change in the short term that will make the care plan more restrictive. The applicant details will be the ICB itself, but you can add the telephone numbers and email address of the case manager dealing with P. P's personal details will then be added, which are quite self-explanatory. You should also consider if P is subject to a detention under the Mental Health Act, a community treatment order, or a guardianship. If P is subject to any of those, we would advise seeking advice, as the COPDOL 11 may not be suitable. If P has made any advance statements in relation to their care or residence, this needs to be taken into account when considering their best interests. And you also need to be satisfied that P does not have any lasting power of attorney or deputy. The OPG 100 form can be used if you're unsure, but this is important to establish, as the court would expect that any power of attorney or deputy are consulted within the application, and it's helpful to have any of the relevant documents available for the court. Finally, the court should be made aware of any previous proceedings in case numbers and final orders that should be included with the application. Rosie will now take us through Annex A.
Thanks, Emily. Okay, I'm going to take you through the Annex A now, and I found the most effective way to do this is simply to progress through the form section by section. So I have put more text than I usually would onto these slides in the hope that they'll be useful to you when you come to write these applications later down the line. It does mean that the text is a little bit small, so you might have to zoom in. But as Heather mentioned earlier, a copy of the slides will be sent to you so that you can have a look at them later on. Okay, so if you have got the form up next to you, we're at page 6 of the form at this point, which is the first page of the Annex A, and this is where you'll confirm what capacity evidence you're providing with the application. So a lack of capacity to make relevant decisions is the gateway to the Court of Protection, and every application needs to go with a COP3. So I'm not going to go through the COP3 form itself because that will be an entirely separate session, but there are a couple of points that I want to make here. So for every application, the form requires that you provide evidence from a registered medical practitioner that P has been medically diagnosed as being of unsound mind. We all know that unsoundness of mind is certainly not a medical diagnosis, and it's a legal concept. So what you actually need to do here is provide the court with evidence of a mental disorder or an impairment or disturbance in the functioning of mind or brain, so that the court can determine whether P is of unsound mind. In terms of how you satisfy the capacity assessment requirements as a whole, the first and most straightforward way is to ask P's GP or psychiatrist to complete both the assessment of capacity and to provide the diagnostic evidence and to link the two. We are increasingly seeing GPs and other doctors refuse to complete the COP3, either due to commissioning or funding arrangements, or because they don't think they have the right experience or expertise. In those circumstances, we suggest obtaining a letter from the GP or other doctor confirming the diagnosis, or a recent clinic letter. Some ICBs have templates which they send out to GPs, which I think are often more successful because the GP has to tick the right boxes and sign the form, and it's much quicker for them to do than perhaps writing a letter. Where you do that, you also need to have an officer of the ICB, ideally a BIA, but anyone who's suitably qualified and experienced, to complete the COP3 and make the link that any lack of capacity is a result of the diagnosis confirmed by the doctor. And a final point on COP3 is, do remember that there must be a separate assessment of each domain on the COP3. So the form, since it was revised, I think it was last year, does now make clear that you need to have the separate decisions. So care and residence shouldn't be considered together. It should be one care, two residents. And if you're looking at the capacity to enter into a tenancy agreement, that should be assessed separately too. And that's all we've got on the COP3. Okay, so moving on to, we're at page 7 now for anyone following along. We're starting to give details of P's circumstances here. So the first box is fairly self-explanatory, but I do think it's important to note that the court wants to know who P is. So try to avoid just listing the diagnoses and their needs, and try to ensure you are painting a picture of P, what they like, who they like, what's important to them. In terms of P's placement, and the details around that. If P is already at the placement that you're seeking the authorisation for, then if they've already moved, ensure the court knows when and whether the move took place with the agreement of all those with an interest in P's welfare and how the transition went. We're looking at the tenancy agreement next. And one important point to note there is when completing this section, in terms of where P lives or will live and whether there's a tenancy agreement involved, if no one has authority to sign the tenancy agreement on P's behalf, authority can and really should be obtained as part of this application to regularise the position for P and to ensure that they have appropriate security in terms of their living arrangements. In order to do that, the ICB does need to be clear on who will sign it, so do think about that ahead of making the application. Okay, we're moving on to page 8, where you're asked to provide copies of the care and support plan, the best interest assessment, and if required, the transition plan. So in the Annex A, you're just going to direct the court to those relevant documents, but a few key points to remember about those documents themselves. The care and support plan should be submitted as a single document. It should be signed and dated by the care provider as the most up-to-date version, and that should be on the front page so the court doesn't have to go digging for it. And it must be dated within the last 12 months. The best interest assessment should demonstrate that the application is uncontested. It should explore key themes such as whether the care plan is the least restrictive option to meet need and whether other options have been considered, and if so, what. Some ICBs submit the most recent CHC review as evidence of a review on best interests. We've seen this work in the past, but results are variable. By and large, the most sort of straightforward and bulletproof way to do it is to have a best interests meeting with all those that have an interest. But again, whatever you submit has to be dated within the last 12 months. A transition plan, of course, only needs to be submitted if P is moving to a new placement. Okay, right, we're at page 9 of the form now, and this is where it gets a bit meatier. So this is where the court is asking you to summarise the key provisions in the care and support plan. And essentially, they want you to be clear about the level of restriction that P is under. So many of these points are covered again later in the form, but as is set out underneath this box, you're expected to answer the later questions with reference to the relevant paragraphs in this summary. So do be mindful of that. So if we look at the specific points then, for the level of supervision, you should be setting out the level of supervision in place, so 2-to-1, 1-to-1, the hours of the day that supervision is in place, and also what the purpose of it is. So is it, for example, to safeguard P's health and well-being or to lessen a particular risk? For the use or possible use of restraint, if it's used, then do include P's PBS plan where it's available and refer to it here with the supporting documents. Either here or in the later section that covers restraint, you should be aiming to set out details of who will implement the measures and their training, how often the measures have been used in the last 12 months and how often the measures are reviewed. The same does apply for sedation as well. I think we're moving on to the next slide. The same does apply for sedation as well. But here you'll be referring to the PRN protocol rather than the PBS plan, and that should be included too. In terms of assistive technology, you want to be thinking about all forms of technology that might be used to aid P. So particularly those which might also be considered intrusive or restrictive, like CCTV cameras, breathing or movement sensors. And finally, you're asked to set out what would happen if P tried to leave the placement. So don't just state, even if it is the case, that if P does not try to leave, or that they couldn't leave without assistance. That is a relevant factor and should be stated, but you also need to think theoretically about what staff would do if P tried to leave and what efforts would be made to return them home if they did manage to leave. One practical point to note on this section of the form is that even if something is not relevant, so there is no use of assistive technology, for example, you should state clearly that it's not used rather than just not commenting on it, so that that is clear for the court. Okay. Right. We're moving on to page 10 of the form now, and we're looking at why this care package is the right one. We're also looking at any changes that have been made recently or that are planned to be made in the near future. So in terms of setting out why the care package in place is the appropriate one, I'd suggest referring back to the best interest review that you've filed alongside the application, whilst also setting out a summary of why the care package is appropriate, and if it's accurate, and it should be if you're at this stage of the form, that all those with an interest consider it meets P's needs and that it's the least restrictive option. In terms of changes to the care package, please ensure that you set out any recent or planned changes, and that in doing so, consider whether a shorter period of review is necessary. So if there's a planned change within the next sort of 3 months to 6 months, you might be asking for a shorter review period than that full 12 months order. And it might be necessary for the court to consider the position again before that usual 12 months is up. Okay. Right, we're moving swiftly on to page 11 and the deprivation of P's liberty. I'm not going to spend a lot of time on this because it's inevitably very, very case specific. But what I'd suggest doing is thinking back to the factors that led to the decision to make the application in the first place. So when you were first reviewing P's care package in terms of whether P is free to leave and whether they are under supervision, continuous supervision and control, refer back to those earlier sections of the form where you set out the level of supervision and what would happen if P tried to leave too. Okay, we're moving on to page 12. Right, I won't go into use of physical restraint and sedation again in too much detail because you've already set that out earlier on in the form. Do refer to those earlier sections of the form and expand in line with the question that the court asks you if you haven't already above. So underneath that form, it asks you to set out the circumstances in which physical restraint or sedation might be used, how frequently, and why such restraint or sedation is the least restrictive measure to deal with the relevant issues. Again, ensure you're referring to the PBS plan and the PRN protocol. One thing I would say is this is a really, really common area for what we call maybe orders, where the court seeks further information. And setting out all of this information at the outset can help to reduce the risk that you end up with a maybe order rather than a final order. Looking at whether P is prevented from having contact with anyone. If there are any restrictions on P's contact which aren't agreed, then I'd suggest seeking legal advice as to whether the COPJOL 11 route is the appropriate one. Even if there are no active restrictions on P's contact with others, we often do see cases where P is wholly reliant on others to facilitate contact. You can still tick no in the box because you're not actively restricting P's contact, but the fact that they're reliant on others to facilitate the contact with others is a relevant factor, so I would pop that in the box in any event. Finally, we're looking at restrictions on P's access to the community. So I'd ensure that while you're setting out restrictions on P's access to the community, as they may be, you also set out what measures are in place to support P to get out into the community and what support is given to them while they're out. You can provide a copy of P's activity planner with the application so that the court can see what sort of steps are taken on a daily basis to try and encourage them to access the community in a safe way. Right, we're on to page 13 now, we're galloping through. So here you're asked to set out any other relevant factors that relate to the deprivation of liberty. Now, by this time, you've often provided granular levels of detail as to P's care plan, and you might not have anything else to say. This box can be used, though, as a continuation if you, for example, fill the character or word limits in any of the boxes above, so long as you're clear about which question it is that you're going back to answer. You're then going to set out why the deprivation of P's liberty is imputable to the state. Presumably, if you're making the application, then you're in a situation where the ICB is commissioning the care package. And on that basis, any deprivation of liberty arising is imputable to the state. And quite simply, that's the answer to the question. You don't need to go over and above that. In terms of the statement of best interests, which starts on page 14, at part A, you can refer back to your best interest review filed with the application, and then you need only really set out a summary of why the current arrangements are in P's best interest, referring to that longer document and that more in-depth analysis. And part B of the statement of best interest requires you to set out the likely harm to P if they weren't deprived of their liberty. It's important to ensure to address all elements of this question. So underneath the main heading, the court often puts little prompts for you in those boxes. And the elements of the question here are what the harm would be, how serious it would be, and how likely it is to arise. So in terms of all harm which may occur, ensure you're covering all three of those points. And one important point I would like to make here is that you must not be afraid to say that P would be at high risk of death without the care package and restrictions, if that truly is the case. I've found that case managers can be hesitant to use the word and to put it in such stark terms, particularly where family members might need to see the application if they have the role of 1.2 representative, etc. But often that is the real risk if the package of care were to be removed, and we want to be full, frank and honest with the court on that. Okay. Now, you'll be pleased to know we've almost made it to the end of Annex A. We're now on to page 15, where you're asked to set out over the course of 2 boxes why the deprivation of P's liberty is proportionate and the sort of least restrictive option available. You can refer back to the best interest review and reiterate your assessment of the risk of harm on the page before. You will note as you move through this form, or you'll be familiar with the fact that there is a lot of repetition here and there is a lot of cross-referring back to statements that you made earlier, and you should feel confident to do that. You don't need to reinvent the wheel, you don't need to set it all out again, you can just refer back to something that you've said earlier, on the premise though that you must still be answering the question that's being asked. So ensure you do a summary here of the less restrictive options which have been considered when and why they weren't appropriate. These measures, as I said earlier, should have formed part of your best interest review and should be well documented in the best interest review that you're filing with the application. But you know, there's no harm in sort of going over them again here and ensuring that they're included in summary. Okay. Finally, we're at page 16, where you're given a lot of space to set out why the application is suitable for the streamlined procedure. So happily, as I referred to earlier, there is guidance within the form itself at page 31, which sets out when an application may not be suitable for the streamlined procedure. So I'd suggest using this as a checklist and ensuring that you can reverse each of those points to show why the application is suitable for the streamlined procedure. So essentially, by the time you submit this application, you want to be in a position to say, first, that all those with an interest in P's care have been consulted and that they agree with the current or proposed package of care and that it's in P's best interest. Secondly, that there are no objections to P's current or proposed placement and care package, referring again to the best interest review and also to the comments in the Annex B, which Liz will come on to shortly. Thirdly, that appropriate steps have been taken to consult P and that P appears content and settled with the current arrangements. Now, that can usually be achieved with reference to the Annex C, which is the consultation with P. And again, Liz will come on to that shortly. And finally, you need to be able to say that all those with an interest in P's welfare agree to the application and that they want it to be determined on the papers without the need for an oral hearing. If there's anything arising that anyone involved or the court thinks would require an oral hearing, then it's highly unlikely that the matter will be suitable for the COPDOL 11 streamlined process. All right, with that, I'll hand you over to Liz, who is going to take you through the remainder of the form.
So we're now going to move on to Annex B. Rosie's gone helpfully through the first section. This section is concerned with ensuring that those involved in the care of P have been consulted and are providing their views on the application. Whilst P is at the centre of any application, clearly those who are involved with it need to be able to confirm, as Rosie stated at the end of the last section that they have been consulted and they are in agreement. And again, just reiterating to the point, if there is any disagreement between those involved in care, it is likely that the COP.11 procedure is not appropriate. So who should you consult with? Well, you need to consult with at least 3 people, and they can be varying from family members, those involved with nursing or care staff, and they should be asked for their views to the questions. So the section of the Annex B that you complete should be completed by you having had those discussions with those individuals, rather than those people being asked to confirm and fill in that part of the form itself. Moving on to the section 1.2 rep, and this is an issue that we have a lot of discussion around with clients. It's often the bit which causes the most delay in completing a COP.11 form and getting an application in, because it requires liaising with the proposed rep. So the proposed Rule Point 2 representative is the person who is going to be appointed on behalf of the patient for the purposes of the application. That person must be able to have oversight of the care plan, must be able to have an understanding of the care plan, and must be in agreement that it is in P's best interest. It can often be a family member. It doesn't have to be. It can be a friend or someone involved in P's care, but it shouldn't be a care provider, and it's unlikely to be a case manager or yourself as completing the COP.11 form itself. In the event that there is no one to act as 1.2 rep, it is often the case that a professional representative is appointed on behalf of P. If there's more than one person willing to act, again, include all details of those people. As it says on the slide, the court is cautious of a main carer or care provider being 1.2 rep due to the potential conflict of interest. So what the 1.2 rep role is to be the person who essentially monitors the care arrangements and the ongoing arrangements for P, and where there are concerns to raise these with the authority, or if necessary, bring it back to the court. In terms of once you've identified the proposed 1.2 representative, it's essential that they understand what their role is, and the best way of doing this is to provide them with the guidance from the case of VE. This sets out fairly clearly what their role is. And then their 1.2 rep should be asked to provide a statement, preferably in the COP24 format, that confirms that the following issues are set out here, that they have the relationship with P and they are willing to act as 1.2 rep. That so far as possible, they are setting out the patient's wishes and feelings. They agree that P has had decisions made in their best interests. They have to have sight of the care plans and the proposals for care plans and transition plans and the application in order for them to be able to confirm this. They also need to confirm whether they consider an oral hearing as required, and they need to confirm as far as possible that the package of care is in that person's best interest. They should also really be able to confirm that they've read and understood the VE guidance, which sets out how they will continue to monitor and undertake their role as proposed 1.2 rep. That 1.2 rep is then put forward as the person who acts on behalf of P. Also within Annex C, it is necessary for someone to consult with P. Again, it comes back to the central part of the application, that P is at the centre of any application and is at the centre of COP proceedings. It is often the case that the proposed 1.2 rep knows P best and can have that consultation with P and can complete the Annex C part of that form. If they have a good rapport with P or they can help to build one, it's appropriate for that person to be present during the consultation. But it can otherwise be a case manager or BIA who can have those conversations. There's a series of questions that you need to take, you need to go through to comply with Annex C, and they're set out quite clearly within the form. So it's necessary to go through those and be able to complete those having had the consultation with P. One point that we've raised on there is that to ensure that whoever completes knows to record facial expressions and any other responses from P when given this information, not just verbal responses. So if there is a situation where P is unable to respond verbally, or it's clear that there is no capacity to understand, it's still necessary to record the detail of what attempts were made to have that consultation with P and what, if any, response you did have. Similarly, if consulting P would cause undue distress and it may indicate the application is not suitable, again, you're looking out for any potential objections from P or from any of those involved in P's care. If at any point during the steps of obtaining the views of others, those involved with P's care, the views of the 1.2 representative, or in consultation with P, if at any part of that there's an indication that there are objections to the proposed care package or arrangements, that should be reconsidered, and that again might be an indication that the COP.11 procedure is not appropriate. So just going through a checklist of what Rosie and Emily and I have covered in terms of the COP.11 form and what you need to have that complete application. Clearly, there's the COP.11 form itself, and that's including Annex A and B. The COP3, the evidence around capacity, with the letter from a registered medical practitioner if that is going to be done separately. The COP24 is the statement from the Rule 1.2 representative that I've just mentioned. It may be necessary to provide further evidence from a case manager if there is any complication, but usually a 1.2 representative statement will be required. Copies of any advance decision, LPA, court orders, and including deputyship. The care and support plan, including PBS plan and PRN protocol as required. I've noted the question that's in the chat about evidence of care plans being within the last 6 months rather than 12 months. Care plans are another point where we often have delays in COP.11 applications, in that we will have a care plan at the start of pulling together the information for an application, which subsequently becomes out of date by the time either the application is filed or by the time the court looks at it. So yes, if a care plan can be within the last 6 months, that's even more helpful. I mean, it should ideally be dated from the weeks, days preceding when the application is put in. Appreciate that's not always the case. And yes, there has been, obviously, we're all aware of backlogs at the court where they're asked for an updated care plan, and we have to go back to the beginning and get that care plan, and that can sometimes set a train of then going back for further information that has also subsequently become out of date. So a contemporaneous care plan as recent as you can possibly find it is obviously the way forward. And again, as pointed out there, that would include the PBS plan and PRN protocol if necessary. Best interest documentation, review documentations of best interest meetings or decisions, a transition plan if applicable, and a draft order. There is one in the Court of Protection. When we provide COP.11s on behalf of ICBs, we would draft that on behalf of clients, and the application fee. The only thing that is not on there is the copy of the tenancy agreement, which may also be required if we're asking the court to provide authorization for the ICB to sign a tenancy on someone's behalf. Just going back to the application fee, in order to submit the application, the best way is via a PBA account. It's not always the case that ICBs have a PBA account, so that's something you might need to look at internally. So what happens then? Rosie, what happens then?
Thanks, Liz. Okay, in terms of what happens after submission, we've referred to it a couple of times already, and I think someone in the chat has also referred to it. You're all aware, I imagine, that there can be a good length of time between filing the application at court and receiving a response. In some cases, we are seeing the length of time reduced more recently. I think Liz recently had one where it was turned around within a week or two, but that seems to be inconsistent. We haven't had others that have been dealt with quite so quickly. But when they are considered, if the court is satisfied that it's appropriate, then the judge will consider the application on the papers without the need for a court hearing. And the application will then either be approved and a final order will be issued, Or it might be returned to the ICB to provide further information with what we refer to as a maybe order. Now, maybe orders can be as simple as requiring provision of an up-to-date care plan or an up-to-date document, given something that's been filed by the time it's been considered is now over 12 months old. Or it could be more complex, seeking witness evidence to address a certain issue that the court's picked up on. These maybe orders have a deadline for compliance. It's important to comply with them by that date and to make sure that you're providing the information that's being requested, because quite simply, if you don't, you may well end up with another maybe order, or the judge may well lose patience and list it for a court hearing in any event, and then it'll be taken out of the streamlined process. So important to ensure that you're answering all of the questions that you're asked to within any maybe orders. If the court is satisfied with the information that's provided, then the deprivation of liberty will be authorised for a maximum period of 12 months. So you might well have requested a shorter review period, or the court might have felt it necessary to review again at an earlier stage. So it may be that the final order is for less than 12 months. When you receive that final order, you need to provide a copy to P's care provider so that they know that the care that they're delivering is in line with lawful authorisation, and also to the Rule 1.2 representative, who should now have been appointed within the order, because there are provisions within the order for the Rule 1.2 representative to keep everything under review, and they need to be made aware of the obligations on them in that respect as well. Okay. In terms of the final order then, a few usual provisions that are contained within it. So the final order will most often say that if there are changes to the care plan proposed that make it more restrictive, then the ICB must apply to court for review before any changes are made. However, the court is understanding that there may be occasions where changes are required urgently. And if that is the case and changes are made as a matter of urgency without authorisation, then the ICB needs to be making an application as soon as possible after those changes have been implemented. So what we shouldn't be doing is just waiting until the sort of review period rolls around and then updating the court. We should be reacting to the changes that are made to ensure that we've got appropriate authorisation in place. If there are no changes throughout the review period and the ICB remains responsible for the package of care and the care plan remains the same, or no changes rendering it more restrictive have been implemented, meaning that an earlier application was required, then the ICB usually must apply to court to renew the authorisation 1 month before it is due to expire. What I would say is start work on this early, because it often takes more than a month, I'm sure you're all aware, to gather all of the relevant documents, the supporting information, to get your care plans in order, to get the COP3 sorted. It can be a more lengthy process, and in order to put the application in on time, we usually advise starting work on it a couple of months before that. So that you've got up to 8 weeks really to gather the information. If you know that there are particular issues that require more consideration for a particular application, then start even earlier than that, on the proviso that you need to ensure your documents don't go out of date in the meantime. So that's a sort of summary of what happens after you filed the application, and I'll hand back over to Liz, who's going to go through some top tips with you.
So finally, top tips. From a practical point of view, we're aware of issues that come up again and again in terms of completing the application. And the bits within the application that cause delay, I mentioned before that obviously engaging or with a 1.2 rep, particularly where they are families or other people, can cause some delay. So the top tip is clearly consult with the family and those involved with P's welfare as soon as possible. And that's both in the terms of the initial application and subsequently, as Rosie said, in terms of if there's a renewal. Obtain all materials in advance of completing the form if you can. Again, this is a focus on the care plan and goes back to that question around, when the care plan should be dated. It should be as up to date as possible. Use plain, simple language in the forms. There is a lot of repetition within the form, and it is okay to repeat yourself in those forms, but provide as much detail and context as you possibly can. Try not to put in quotes from care plans or quotes that don't explain the actual context. That we recently had an issue where a comment made without context had given rise to concern by the court, which ended up requiring much additional information, and it could have been, I think, addressed had the context of the initial comment being put in been explained slightly more in the form. If you notice gaps or discrepancies, the chances are the court will too. If there are an issue around someone's opinion that is suggestive that they're objecting, investigate it further. And if it is an objection from someone involved in the care, then I take the view that actually this is not going to be appropriate for the COPDIL 11 streamlined procedure. I've mentioned before, it's okay for some of the responses to be repetitive. Use a draft index to keep track of what documents you have and what you are awaiting. Obviously, we've provided a checklist, so you go through that checklist so that you know exactly that you have everything that you need, and file updating care plans while waiting for requests from the court. I'm just going to open it to Rosie and Emily to see if there's any other top tips that we've come across. Otherwise, it may be something that comes up in the questions. We are aware that a COPDIL 11 can be a very straightforward, simple application in some instances, but in other instances, getting the information required to make the application can take a considerably longer time. And those issues with dates expiring on care plans are being seen more often. Once you have done one or two of the applications, they'll become very familiar to you, and what is required of the forms and the information you're expected to put in will become clearer to you. But they are always specific to P. So although we are going through the form in terms of what and how to address those forms, we should always bear in mind that they should be person specific by their very nature. So I think we do have time for questions if there are any. There are a couple in the chat. I think we addressed the first one about care plans, and we've come back to that. The question is it important to include all medication that has the potential to have sedating side effects, such as anticonvulsants, or just medication that sedates as a way of managing behaviour? And the question relating to sedation is around sedation that is around medication that is used for sedation. So that would be the key point. But I think in terms of for completeness, details of medication should be included, and that would be included presumably in a care plan in any event. So if the question around sedation should include a medication that is used specifically for sedation, my view would be, I don't know if Rosie, you've got a different view on that.
No, yeah, I agree with that. I think if there are medications that are used for other means that have particularly sedating effects, then you could draw the court's attention to those, but making it clear that they're not used for the purpose of managing behaviour and they're used for managing some other condition instead.
Thank you.
Right.
There is another, I'm not skipping over that reference to the paper, but I'm not sure that was with a question. So if it was, correct me if I'm wrong. The question about are paid 1.2 reps required to complete reports on review of arrangements? What about informal 1.2 reps? As far as I'm aware, there's no requirement to complete reports as part of the COPDIL 11. Am I wrong, Rosie?
There is, in the final order, there's often provision for the Rule 1.2 representative to provide updating information on the implementation of the care plan. It's usually 14 days before the end of the review period. Often the way that we see that dealt with in practice is the Rule 1.2 representative will provide another COP24 witness statement, just reiterating any recent review that they've undertaken of the implementation of the care plan, and restating the REVE requirements in terms of the care plan being in P's best interest, etc. As we went through earlier, and in my experience, informal and paid 1.2 reps would undertake that role and provide that information for any renewal. Does that deal with your question, Amy?
Perfect, really helpful. Thank you very much.
Thank you.
Can the 1.2 rep be a family member even if they are one of the main care providers. The 1.2 rep can be a family member. I suppose it depends on whether there's a risk of conflict. If that family member as a care provider is the person who is instigating the care arrangements and the restrictions in particular, then there's a potential conflict. But I think it turns on its own facts. I think if there is someone who has oversight of the care package who is not involved in implementing the care and the restrictions, that person would be more appropriate.
Yeah, I think just to add, some judges take conflict of interest in that scenario sort of more highly than others, but it would be very case specific, and it would depend on the actual situation and the role of that person in P's life. Jenny, I can see you've got your hand up. Did you want to ask a question?
Hi, Rosie.
Hi.
Rosie, I just wanted to go back to something you said earlier about it would be good to have the person who's doing these as a best interest assessor.
Yes.
And
in terms of the COP3.
Yeah, and I suppose there's nobody on our team who's best interest assessor, and we have raised it a couple of times that we would like to get this training.
Yeah.
Does it make a difference? Because I think what we've been told is, oh, it's all right, just do it anyway. And I always feel with the dolls and any work to do with the dolls that I'm peeing in the wind, really. So I personally would like it, but I'm just wondering, am I just like looking for a little badge to say I'm okay to do it, or is it just that it is necessary?
No, I think BIAs have very clear and specific training on this type of thing and on assessing capacity. It's not to say that a nurse who isn't a BIA or someone else who isn't a BIA can't assess capacity, but you have to be able to state within the form what relevant experience and expertise you have, which makes you competent to do it. So the important thing is ensuring that you have that expertise, irrespective of title, to enable you to assess somebody's capacity.
Okay.
All right.
Cheers, my dear. Thank you.
Thank you.
There's a further question in the chat about a particular person who attends day centre receiving one-to-one support, and there's no paid support provided within the family home where P is cared for by the parents. So does this satisfy the first limb of the acid test? I think it's difficult to know that without more information. The acid test is around continuous monitoring and care and support, and I think we'd need to look at that in more detail. I'm not sure we can give you a quick answer to that one, I'm afraid. When a medical person provides info re mental capacity of the patient, do we need to complete a face-to-face mental capacity assessment? Rosie?
So capacity assessments don't necessarily need to be face-to-face, but there does need to be an assessment for you to complete the COP3 form. If it was to be completed remotely, for example, then you would need to set out what steps have been taken to enable P to properly sort of engage with that process. I think by medical person, you probably mean a registered medical practitioner. You don't need a registered medical practitioner to assess capacity and a BIA or a social worker. You can just get the registered medical practitioner to do that if they are willing.
It just goes back to about the representative. So, somebody who has like a PHB and the family is classed as the employer, could they be the representative, or would we need to refer for like an IMCA, like an advocate? Because I think there's been some mixed messages from our locality with who can sort of have those best interest discussions about restrictions and care and support and place of residence there. So should we refer to an IMCA if the family member is like the classed as the employer? Because in a lot of PHB cases, that is usually the case.
Yeah, again, I think case specific, so we can't comment for every single situation, but that might be one of the situations where you consider that someone independent of the care package would be better placed. Doesn't necessarily mean that you need a specific IMCA to do the role. It could be that you just consider a family member that isn't so closely involved in commissioning of the package.
Right, okay, thank you.
The question: if there are disputes or concerns with the care that will lead to an oral hearing, we still submit via COP.11? 11? You're mentioning forms. I wasn't sure if you indicate another form to use. So if there are disputes or concerns with the care, if there are objections to the care, if there are family members or disputes around whether the care is in P's best interest, then you shouldn't be using the COP.11 streamlined procedure, I think, is our advice. Again, it's case specific, but it's likely that that will need an application to the court, which requires an oral hearing, and then the COP.11 form is not the correct application to access the Court of Protection. The court is very clear that the COP.11 streamlined procedure is for that. It's following the REX case, and it's where there is no objection, there is no issue particular that will give rise to the need for additional representations being made by various people involved in P's care. So if there is dispute, then no, COP.11 is not the way to go. What else have we got? If P has an LPA and is in full support of the care arrangements, but we are aware that other family members have objections, do these need to be consulted? Yes, is the short answer, but again, that might give rise to not being COP.11. It might give rise to a more wider application, which we haven't gone into here, but I think yes is the answer. Claire, you've got your hand up.
Yes, and I did put in the chat. I was a bit surprised what Rosie said, and I may have misunderstood it. I've always been led to believe that you do need to do the mental capacity element face to face now, and you need to see P. But what you might have meant is then a different person could complete the COP3 to that person, and therefore that wouldn't necessarily be the same person. But we always do our MCA face to face. We always go and see P. We never do it. I mean, in COVID, we did it differently for a short period of time, but now we always do that face to face. But it's us, as the BIAs, as we are, completing those documents. So, just wanted to check out. I hadn't misunderstood your advice, Rosie.
No, absolutely not. I think you're right. It's absolutely preferable to have that assessment completed face to face. There's no question about that. That's the best way to understand what P is trying to tell you in any responses, and it's the best way for you to engage with them in 99% of cases. But there may be cases, and it's acknowledged in the form COP3, where you could assess P remotely. So there is a question within the form which asks you which method of assessment you use, so whether you assess them face to face or whether you assess them remotely. If you tick the box to say that you assessed P's capacity remotely, then you're required to set out the steps that you took to help P to engage in that process. So in line with the principles of the Mental Capacity Act, how did you enable them? What steps did you take to make sure that they could give their best selves to that assessment and that you were properly assessing their capacity? So you'd need to do that. You'd need to set that out. If the court wasn't satisfied that the method of assessment was appropriate, then that's one of the ways in which they'd raise issues, which may then lead to further exploration, the need for further evidence, etc. But it's certainly not precluded to complete remote assessments. It's just, I would say, not desirable.
Whoever does the capacity assessment has to have an understanding of what they're doing and why they're doing, and the actual, I mean, obviously, because they're required to set out, as Rosie said, their qualifications and experience, and they have to have an understanding of the MCA and that test. So how that is then managed on the ground, I think, as you say, will vary from patient to patient.
Yeah, I think that's absolutely the point to make here. It should be person specific. And if a remote assessment is felt by the assessor to be the most appropriate way to assess P, then fair enough, but they need to justify that. As I said, in 99% of cases, you're going to be wanting to go out to see P directly to make sure that you can give the assessment your best.
I've just noted one of the comments noted one of the comments saying, I attended a court user group recently and the judge made it clear that remote assessments are not acceptable apart from exceptional circumstances. So, I mean, I think that backs up what we're saying. There has to be justified. There has to be a reason for it.
Yeah.
I don't think there's anything else. So I think we'll probably bring it to a close.
Yeah, brilliant. I think we're done.
Thank you all very much indeed, to everybody who's attended and also to our speakers this morning.